Welcome to this MBL session on UK customs and intellectual property enforcement, protecting your brand at the border. Before we begin, I want to make clear this session is intended for training purposes. The content we cover today is designed to give you a practical overview of the subject area. If you're dealing with any specific issues that we raise during this session, we recommend that you seek specific legal advice. The slides from today's session will become available after we finish. My name is Tom or Thomas Hooper. I'm a brand protection lawyer in the London IP team of Bird & Bird. My practice focuses on helping clients in all aspects of trademark and design law. I handle related disputes and contentious proceedings before the courts and the registry. Brand protection, including customs enforcement, is central to my practice. So what will we cover today? Let me start with a brief roadmap of the session. We will work through these 10 connected areas. We'll begin with why custom enforcement matters in the first place and the role that intellectual property plays at the border. We will then look at why trademark and design registration are the essential starting points to any border enforcement strategy. We will consider what changed after Brexit, because UK and EU customs enforcement are separate regimes and they need to be managed accordingly. We will then get into the practical mechanics. So how does custom applications work? What happens when the goods are detained? Why are deadlines absolutely critical and how to manage them? And a few practical points and case studies around those. By the end of this session, you should understand these things you see on screen now. And before we get into the detail, I want to give you the 3 core ideas that underpin everything in this session. A registered IP right gives you the legal foundation, whether that is a trademark, a registered design, or another right. Without a registered right recorded at customs, you have a very limited ability to use it effectively. A customs application creates the opportunity to intervene. Filing an application for action, which is frequently known as an AFA, is what activates the enforcement mechanism. Your internal processes then determine whether you can act in time and take action. The legal right and the customs application create the conditions for enforcement. But whether enforcement actually happens depends on how your organization manages that notification, or your lawyers acting for you. So hold those 3 connected ideas in mind as we work our way through the session. So why does customs enforcement matter? There's a fundamental question. Customs can provide a first line of defense for anti-counterfeiting goods, but have you recorded your AFA already? If not, that's the place to start prior to registering your IP. So the first line of defense is exactly the right framing because the border is the earliest possible point of intervention in the journey of a counterfeit product into the country. But why does intercepting counterfeit goods actually matter? Let's take each point of this in turn.